Good morning, my students. It is nice to be with you once again. My name is A.F. Afolayan, and I'm presenting on behalf of Abuja campus. So today we are dealing with Appeal 2. Last week we dealt with Appeal 1. Today we are dealing with Appeal 2. So please listen attentively and enjoy the lectures. Thank you. So in today's lecture, the outcomes are students will be able to draft notice and grounds of appeal, prepare and argue application for bail, pending appeal, prepare briefs of arguments, identify types of orders the court can make after hearing appeals. Students will also be able to explain the procedure for application for leave to appeal or to amend notice and grounds of appeal, abandonment of appeal, abatement of appeal, additional grounds of appeal, additional evidence on appeal, hearing of appeal at the Court of Appeal and Supreme Court. So now we go to application for leave to appeal. So where parties do not appeal within time, the leave of court must be sought to appeal out of time. The application, which is by motion on notice, is to be filed in the court below and must be supported by affidavit and the proposed grounds of appeal. On this, please see Order 17, Rule 4 of Rule 1 of the Court of Appeal rules. The application must contain reasons why the appeal could not be filed within time. Let's go to bail pending appeal. Bail pending appeal. An accused or a defendant who is convicted and sentenced and who is dissatisfied with the judgment and intends to appeal may need to apply for bail pending appeal. On this, please see Section 283 sub 4 of the Criminal Procedure Code Law, Section 340 sub 2 of the Criminal Procedure Code Law in respect of appeals from area court to the High Court. Then Section 28 sub 1 of the Court of Appeal Act in respect of appeal from the High Court to the Court of Appeal, and Section 31 sub 1 of the Supreme Court Act, and also Order 9 Rule 4 sub Rule 6 of the Supreme Court rules in respect of appeal from the Court of Appeal to the Supreme Court. Bail pending appeal is not a right. This is because an accused person who is tried and convicted and sentenced and who intends to appeal need to apply for bail pending appeal. So the appellant in this case had already been tried at the lower court and found guilty and convicted before this present appeal. Thus, the appellant can no longer be presumed innocent. He can no longer enjoy the presumption of innocence that is contained in the Constitution. So the appellant must establish special circumstances to be entitled to pending appeal, or technical cases where there is a serious health ground that the corrective centers cannot adequately cope with, like in Afolayan against the state. Then where the convict will serve his sentence substantially before the appeal is heard and concluded. On this, you can see the case of Obi against the state. Then the court will also look at the severity of the offense, if it is, whether it is a serious one or a simple one. On this, you can see the case of Bode George against the Federal Republic of Nigeria. Note that persons convicted of murder and sentenced to death are usually not released on bail. Where there is a mistrial, or the trial was not properly conducted at the lower court, and this is reflected on the face of the records, it can be a ground. Then where the grounds of appeal filed was so substantial that there is a good prospect of success of the appeal. On this, you can see the case of Chukwunyere against the Commissioner of Police. In all these situations, they are considered to be special circumstances upon which bail can be granted pending appeal. The application for bail pending appeal should first be filed in the trial court, and if refused, it should be filed in the court where appeal is pending. So if the appeal is from the High Court to the Court of Appeal, it should first be filed in the High Court, and if refused, it should be filed in the Court of Appeal. Such application is by motion on notice and not by summons. On this, you can see the case of Obekpa against COP, Ofiong against COP. Hearing of appeals at the Court of Appeal. The hearing of appeals at the Court of Appeal is by brief of argument, and brief writing was introduced in the Court of Appeal in 1984. The appellant is to file his brief within 45 days of receiving the record of proceedings. On this, you can see Order 19 Rule 2 of the Court of Appeal rules. The appellant's brief is a succinct statement of his arguments in the appeal. Then, after the appellant brief is filed and served, the respondent is to file the respondent's brief, and he must do this within 30 days from the date he served with the appellant's brief. On this, please see Order 19 Rule 4.1 of the Court of Appeal rules. The respondent's brief is a succinct statement of the respondent's response to the arguments raised in the appellant's brief served on him, and it must be duly endorsed with an address or addresses for service. Brief of argument generally must be endorsed with the address or addresses of service, and it must be signed by the counsel that is settling it. Reply brief is usually filed by the appellant, that is where necessary, and this he must do within 14 days from the day the appellant is served with the respondent's brief. On this, see Order 19 Rule 5 of the Court of Appeal rules. Reply brief is only to deal with all new points arising from the respondent's brief. Each party is expected to file 10 copies of his brief, whether appellant's brief or respondent's brief or reply brief. 10 copies of brief and plus 2 e-copies, and the brief must not exceed 14 pages. On this, see Order 19 Rule 8 of the Court of Appeal rules. We may have to also consider the effects of Court of Appeal Practice Direction 2013, particularly Section 9A to D thereof, with respect to some cases that is covered by the practice direction. Such cases are terrorism, rape, kidnapping, corruption, money laundering, human trafficking, and interlocutory appeals challenging the ruling of the court below on an interlocutory application. In all these cases, priority attention is usually given by the Court of Appeal in hearing these cases. Brief of argument in cases covered by the practice direction. The appellant must file his brief within 14 days of receiving the record of proceedings. The respondent must file his brief within 10 days of receiving the appellant's brief. A reply brief must be filed within 5 days after service of the respondent's brief. No oral elaboration of brief is allowed except by the order of court. All applications must be resolved within 21 days of filing the last document. In hearing the appeals, priority attention shall be given to all the cases listed above, and in preparing the court list, those cases shall be mentioned first. The judge may designate certain days in hearing the appeals and shall not entertain frivolous applications for adjournment. So on this, see section 3B to D of the practice direction. Hearing of appeals. On the date the appeal is set down for hearing, each party is given 15 minutes to argue or adopt his brief. On this, see order 19 rule 9(3) of the Court of Appeal rules. Cross appeal. This is an independent appeal filed by the respondent against the judgment of the lower court. Such appeal is heard at the same time as the appellant's appeal and is determined in his own merit. Respondent's notice. The respondent is contending that the decision of the court below be varied either in part or in whole. The respondent may also contend that the decision be affirmed on grounds other than those relied on in the court below. Contents of brief of argument. The brief of argument must contain the following: the name of the court, where the appeal is to be heard, the appeal number, the parties to the appeal, name of parties to the appeal, the title of brief, whether it is appellant's brief, respondent's brief, or reply brief, table of contents, introduction or preliminary statement, issues for determination, statement of facts, arguments on the issues, conclusion or summary, and the list of authorities. It must also contain the name, address of counsel settling the brief. Brief of argument must be signed and dated by counsel filing it, as said earlier. Brief of argument at the Supreme Court. It was first introduced in 1977. The appellant is to file his brief within 10 weeks of receiving records. The respondent is to file his own brief within 8 weeks of receiving the appellant's brief. The reply brief must be filed within 4 weeks of receiving the respondent's brief, if any. On this, see order 6 rule 5 of the Supreme Court rules. Parties are expected to file 10 copies of his brief. And 1 hour is given to each party to argue or after hearing appeals. These are the orders the court may make after hearing appeals. Number 1, the court may allow the appeal. In this case, the decision of the lower court is reversed. This is done where the appeal succeeds. The conviction of the accused or defendant will be quashed and he will be discharged. The second order the court may make is to dismiss the appeal. This is done where the decision of the lower court is affirmed, the conviction of the accused will be affirmed, and the appeal dismissed. The third order the court may make is to reduce or increase sentence. This is done where there is appeal on sentence. Usually when there is appeal on sentence, the court can make a pronouncement on sentence. The court can increase the sentence or reduce it. But if there is no appeal on sentence, the court will not go into the issue of sentence. 4, alter findings but maintain the sentence. The court may alter the findings of the lower court but maintain the sentence that is already pronounced. Then 5, the court may uphold plea of insanity and annul conviction of the accused. This is done where the accused entered a plea of insanity at the lower court. Then the court may also order rehearing. The court may order rehearing of the whole matter. Order for retrial. These are the cases or occasions where court may order a retrial. This is done where it will not amount to a miscarriage of justice to do so. So rehearing is ordered where it will not amount to a miscarriage of justice to do so, or where it will not be oppressive on the accused to put him on trial the second time. Retrial is ordered where vital evidence relating to the trial have not been taken at the court below, or where the witnesses that testify at the court below are still alive or available and they can be summoned to appear before the court to come and testify again, or where there was an error in law or irregularity in the proceedings at the lower court, or where the evidence taken as a whole discloses a substantial case against the appellant. In all this, the court may order a retrial. Now let's go to abandonment of appeal. Let's first consider appeal from magistrate court to high court. This will involve filing of notice of abandonment by the appellant or his counsel at least 2 clear days before the hearing of the appeal, and the filing will be done at the registrar. The filing will be done before the registrar of the court below. Then in appeal from high court to the court of appeal, the filing will be done by using criminal form 11 or 11A, which is headed notice of abandonment of appeal, and filing of same before the registrar at the court below. Then if it is an appeal at the Supreme Court, it is only a letter from the appellant informing the registrar of intention to abandon the appeal. Then please note that an appellant may impliedly abandon his appeal if he fails to file the necessary papers to prosecute his appeal after filing his notice of appeal. So maybe he just walk away. So the court in that circumstance may consider the appeal as having been abandoned and strike it out. Then let's consider abatement of appeal. Abatement of appeal arises where the appellant dies before his appeal is determined. Criminal appeal may survive the dead appellant where the appeal is against fine, as the judgment of court may be executed against the estate of the deceased appellant. The authority on this is the case of R against Rowe. See also the case of Abdullahi against the Nigerian Army. It's a very recent case, 2018 case. The citation is on the screen. All right. Now let's go to additional grounds of appeal. What constitutes additional grounds of appeal? Proceedings or as the need arises. However, the leave of court is required to file additional grounds where the time to file the notice of appeal has expired. Appeal is argued based on the grounds of appeal filed before the court. So where issues are raised in your brief, you must show the grounds to which such issue relates. So if there is no ground upon which the issue relates, then the issue you have raised will be deemed abandoned, since it's not covered under any grounds of appeal. Where the evidence sought to be adduced was not available before the trial, the evidence is relevant to the issue before the court, or where taking fresh evidence will not amount to rehearing of the matter. So in all this, hearing of appeal from magistrate court to the high court, hearing of appeal from magistrate court to the high court, the composition. In the south, at least one judge of the high court presides. See section 273 of the constitution. In the north, at least two judges of the high court presides. See section 63 of the high court law of northern Nigeria. It was held in the case of Ishola against Ajiboye that it is not unconstitutional for the law to have demanded or required two judges of the high court to preside over appeals in the high court. Constitution of the Court of Appeal. Three justices of that court sit to preside over the case. See section 2471 of the Constitution. In special cases, not criminal appeals anyway, the president of the Court of Appeal may empanel 5 justices of the court to sit over a matter. But as I've said earlier, this is not applicable to criminal appeals. Appellate jurisdiction. The Court of Appeal may hear and determine criminal appeals from the following courts: the Federal High Court, the National Industrial Court of Nigeria, High Court of the Federal Capital Territory, High Court of a State, Court Martial, Code of Conduct Tribunal, and any other tribunal that is established by the National Assembly. Constitution of Supreme Court. 5 justices of the court sit to hear appeals. The full court of the Supreme Court is 7 justices. See section 234 of the Constitution. A judge may write a judgment and give his learned brother to pronounce. All right, thank you. This is the end of the lecture. I've also uploaded a precedent of a notice of appeal and the grounds of appeal that is filed before the Court of Appeal. Thank you and have a nice day.